Okay, and we are going live right now.
Hello, everyone. Good morning. Today, we are going to present this Power of Attorney educational seminar, and our presenter is Elizabeth Byer. Go ahead, Elizabeth. You can go ahead and.
Thanks. Good morning, folks. We are doing a Zoom presentation, and if you don't have the documents in front of you, Nevada Legal Services will send them to you, and you can contact them for further follow-up. Also, if you need the affidavit done, the office will take care of that as well. You just need to contact the office. So for those of you who do have documents, we're going to start with the durable power of attorney for healthcare. And I need to be able to screen share, so if someone could fix that. And let me know when that has worked.
Elizabeth, I think if you go to the bottom of your screen, you'll be able to see share screen.
On it. Okay. Thanks. Okay, are we sharing screen at this point? I have share screen up.
I think it's going to ask you to select the document.
Got it. Thank you. Okay, so if you see in front of you the durable power of attorney for healthcare decisions, this document is good in Nevada. It is also good in other states if you are a Nevada resident. However, if you are spending any time, significant amount of time in California, you'll want to get their document, which is different from this one. So you can read the preamble, which there's a couple of pages, and then move on to the designation of healthcare agent. So under number 1, you will want to choose your healthcare agent. Most people choose someone within their family. If you don't have a family member, it is perfectly fine to choose almost anyone else. You can't choose your healthcare provider. So if you have a regular nurse who's coming into your home to see you, that won't work. Most people choose their children if they're old enough. So it is I, and then you put your name in the first line. Do hereby designate and appoint, and you'll want to put the name, address, telephone number, and email address, any other significant contact information. If there's a text message number that's different from the telephone number, you will want to put that, especially for someone who may be thinking about having to go into the hospital. Any contact information is going to be a valuable resource to the social worker or whoever will be contacting next of kin if they have to. So if you trust your healthcare agent, you really need to have that conversation with them about what your choices are. They're supposed to follow whatever your wishes are and not substitute their own. So having that conversation is really a necessity. After you've filled out the section on designation of healthcare agent, you can continue to read if there are any, for example, in number 4, which starts on page 3 of 8, special provisions and limitations. If there is anything specifically that you do not want your healthcare agent to have control over, you will want to put it in that time. If you in the couple of lines that are after paragraph number 4 and located on page 4 of 8. So, for example, if someone knew they were going to the hospital and they had a neighbor and that was the only one that they knew that could possibly be their healthcare agent, maybe for that period of time, for that hospitalization, you want that neighbor to do that service for you. You already had that conversation about what you want your neighbor to do, what your wishes are. You would maybe choose to have a shorter duration or not complete authorization for the neighbor. So you can put that in number 4 of 8. Specifically for duration, you could choose to only have it be good for a couple of weeks or a month or something like that. So you can have the power of attorney end at a particular time. The most important part of this document is in section 6, and we're going to go over this in detail because it is basically the heart of the document. So on page 4 of 8 and 5 of 8 are the sections A, B, C, D, and E, and F. So I'm going to read these so that we're all very clear about what they mean. A, I desire that my life be prolonged to the greatest extent possible without regard to my condition, the chances for recovery, long-term survival, or cost. So someone could choose in A to have absolutely everything done for them, whatever that means. Stay in ICU for whatever period of time, whatever that cost may or may not be. We always feel that cost should not be relevant to healthcare decisions, but for some folks, those are relevant considerations. But A is for that person who wants absolutely everything done and to be kept alive to the longest and greatest extent possible. B, if I'm in a coma, which my doctors have reasonably concluded is irreversible, I desire that life-sustaining or prolonging treatments not be used. So that's specific to coma, and it goes along with C, which is if I have an incurable or terminal condition or illness, no reasonable hope of long-term recovery or survival, I desire that life-sustaining or prolonging treatments not be used. So B and C are slightly different from each other. And let me explain from a medical standpoint. So someone could have a terminal or incurable condition, but may or may not be in a coma. Someone could be in a coma, but not have an incurable or terminal condition. So those cover 2 different scenarios. And let's look at the next one, which is D. Withholding or withdrawal of artificial nutrition and hydration may result in death by starvation or dehydration. I want to receive or continue to receive artificial nutrition and hydration by way of the gastrointestinal tract, the GI tract, after all other treatment is withheld. So for that individual, they may want to continue to be fed or continue with IVs, even though a respirator or other artificial means of keeping that person alive have been withdrawn. For a lot of people, that D is kind of a heartfelt notion that they want to continue to be fed because they think they'll be hungry. And truth be told, you can take a look at the Hospice Foundation of America's website. Looking at nutrition at end of life, for the most part, people are not hungry. And in fact, there are ketones that are produced by the body, creating a little sense of euphoria. So therefore, people, it's kind of the natural process of dying. People do not necessarily eat, need to eat, or even want to eat as they progress towards death. E, the next provision under this durable power of attorney, it says, I do not desire treatment to be provided or continued if the burdens of the treatment outweigh the expected benefits. My agent is to consider the relief of suffering, the preservation or restoration of functioning, and the quality as well as the extent possible of life. So most people, if they trust their healthcare agent, would choose E. And essentially have the conversation with the healthcare agent, whoever that is, the neighbor, the daughter, the best friend, and say, here's what I really want. I want you to follow my wishes, and give that individual the latitude to make the best decision at the time. Essentially, obviously, A, the healthcare agent is going to say, do absolutely everything for my mother, my husband, my whomever it is. Do everything, keep doing everything, no matter what. There's less of a restriction if E is chosen. And if you choose a healthcare agent that you trust, my recommendation would be to choose E. Moving on to F, if I have an incurable or terminal condition, including late-stage dementia or illness and no reasonable hope of long-term recovery or survival, I desire my attending physician to administer any medication to alleviate suffering without regard that the medication is likely to cause addiction or reduce the extension of my life. So under this provision, which is actually a newer provision in this document, and this document has been around since about 1988, when the first living will document was put into Nevada statutes. So in this particular situation, the individual is giving the ability to choose whatever is recommended. So keep me comfortable is really what this one says. And you can choose multiple paragraphs. You could choose B, C, D if you wanted. It is not the easiest sometimes for healthcare providers to follow wishes or understand what you really have chosen. And essentially this document becomes available and in play when an individual cannot speak for themselves. So in situations of a massive heart attack and someone is on a ventilator and unable to communicate, they've been given medications to keep them comfortable, and also in a situation where they are not aware and of their surroundings so much that they become anxious. So under that, the healthcare agent has to step in. A car accident, then this document is also comes into play. So in these situations, it's not that people have the ability or luxury of then explaining themselves as to what they want. So I would choose, if it were me, and again, you get to choose what you want. If you have a healthcare agent that you trust, choosing E, possibly adding F, may be the easiest for the healthcare agent as well as your healthcare team. What I didn't tell you at the beginning was I've been a nurse for 40 years. I also have a master's in nursing, in addition to working at bedside for decades. I'm also an attorney. So looking at these documents and actually being involved in their promulgation and being put in terms of statute, when I was lobbyist a long time ago, as well as working for Nevada Center for Ethics and Healthcare Policy with the Nevada University of Nevada, Reno. So the ins and outs of these documents are fairly familiar. And if you have questions that you can't answer based upon the conversation that we're currently having one-sided here, you're welcome to call Nevada Legal Services, and someone can talk these through with you if you need, to have you really perhaps understand the implications of your choices. So at any rate, they're supposed to be written in plain English for you to be able to understand. So from a nursing perspective, let me just say that D is for someone who really wants to be fed no matter what. I can tell you from a healthcare standpoint, that is not always the best option for someone who is in a situation where they are likely to die. The stomach can't digest, the body can't tolerate the additional burden of digestion during that process when it is actively dying. So D, you want to think about very long and hard. If you have religious preferences, you'll want to also take all of these pieces into consideration before making a choice. And you may choose to reach out to your minister, rabbi, preacher, imam, to make those choices with them in partnership. So we're going to move on. If there are any additional desires that you have, so for example, someone who's been on dialysis a long time, at end of life may choose to not continue with dialysis. They've got a very specific knowledge of how they've been handling that for as long as they have. And for those people who've been in chemotherapy for a very long time, they may also choose to not have continued chemo. So you can make those choices and write those down in this document. Moving on to paragraph 7. Statements of desires concerning living arrangements. So we're going to go through these as well, reading them. A, I desire to live in my home as long as it's safe and my medical needs can be met. My agent may arrange for a natural person, employee of an agency, or provider of a community-based services to come into my home to provide care for me when it is no longer safe for me to live in my home. I authorize my agent to place me in a facility or home that can provide any medical assistance and support in my activities of daily living that I require. Before being placed in such a facility or home, I wish for my agent to discuss and share information concerning the placement with me. So this is the opportunity to be as independent for as long as possible. It also will go along with the financial documentation that we are going to do in a little bit to indicate that this person wanted to live in their home, and there may be, by reason of dementia, a person may not be safe at some point without assistance. So whether that's 2 hours in the morning and the healthcare agent needs to provide the access to the residence, as well as money to the agency for someone to come in to supervise that individual. So A is the one that will allow independence and keep the person in the home. Number 2, or B, under 7, 7B. I desire to live in my home for as long as possible without regard for my medical needs, personal safety, or ability to engage in activities of daily living. My agent may arrange for a natural person, employee of an agency, or provider of community-based services to come into my home and provide care for me. I understand that before I may be placed in a facility or home other than the home in which I currently reside, a guardian must be appointed for me. So in this particular scenario, the healthcare agent does not get to do that independently. A guardian, which is a court-ordered person, would need to be appointed through the court system. In a legal scenario, what would happen is physicians would provide documentation that the individual is not safe at home, a guardian needs to be appointed, and a judge would then rule that that must be done for the individual. There's also a financial provision that whomever, and again, there are different kinds of guardianship, but often full guardian also must present to the court a complete accounting every year on an annual basis of how that individual's money is being spent. So this basically invokes the courts to come in and oversee the living arrangements for that individual. So one could choose either A or B, and then additional statements. So as long as a person can choose, in other words, speak or write or somehow communicate their desires, even if they are not always rational, the courts and the healthcare agencies fall on the side of allowing for independence and autonomy. And I'll just give you a brief example of this. When I was teaching up at the university, a group of social workers, one of the social workers was telling me about a case she had where an individual was not able to care for herself, basically could not get out of a chair by herself, had no interest in anyone coming into the home, and under those circumstances, because she could reach for the phone, and if someone came into her home and say, you know, I don't want this person in my home, she couldn't bathe herself, could not transfer herself to a bedside commode. So because she had the ability to be autonomous, even though her medical needs and basic hygiene were not being met, even her food situation was questionable, that individual was allowed to remain in her home. So this document would not be relevant in that scenario. When an individual can speak for themselves or communicate their wishes, even though there are poor choices, the community, the healthcare community, the legal community allows for independence. The healthcare agent and the durable power of attorney for healthcare, and then again, even these documents about where will a person live, only become relevant when an individual cannot communicate adequately for themselves. So moving on. 8. So the next pieces here, 8A and B, are if the first designated healthcare agent is not able to provide that service. The social worker can't contact them. They can't track them down. They don't know where they are. It is a wise choice to choose an alternate. You'll see this on the next documents as well. So an alternate agent can be chosen, and really it's in your best interest to choose B and C of whoever that is in your life if you have more than one child. So child A is your first choice, but child B and C maybe second and third. It doesn't have to be the one who is here in state, as long as that person is able to be communicated with by telephone or some means, then you can choose even a person who is not in state as your healthcare agent or your alternates. So 9 revokes previous durable powers of attorney. 10, if there's any conflict of interest, then they should really look at basically, let's just read this. Okay, let me start with that. So if my designated agent is my spouse or is one of my children, then I waive any conflict of interest in carrying out the provisions of this durable power of attorney that they may have by reason that they may be a beneficiary. So in other words, if somebody is family, they can choose to be your healthcare agent. However, a person typically who is a beneficiary in most situations cannot act for you. The courts look at that. So number 10 is basically just legalese to allow someone close to you to be your healthcare agent. So looking at number 11, if the legality of my provision of this durable power of attorney for healthcare is questioned by my physician, my agent, or a third party, then my agent can go to court for declaratory judgment as to the legality of the provision in question. And the cost is to be provided by the estate. So essentially, a court may be invoked to look at it if there is a challenge involved. Okay. Very unlikely scenario, although it could happen. I've sat for a number of years on various bioethics committees in our community. And often if there is difficulty between child A and child B, or healthcare agent A, healthcare agent B, the bioethics team within the facility tries to come to some sort of a consensus within the family. And often that's how that is handled. If for any reason that can't be handled in that way, the healthcare agent has the ability to bring this document forward to court for relief. Okay. 12, nomination of guardian. If after the execution of this durable power of attorney for healthcare decisions, Incompetency proceedings are initiated. I nominate my guardian for consideration by the court as my agent. So in other words, the court is going to default saying, well, this person chose whoever it was for their healthcare agent. That seems like a wise choice as the guardian or conservator. Okay. All right, you can take a look at any of the extra provisions here, and we're just going to move on. You can choose to have this signed and dated as well as a notary. So you would bring the document into our offices and have it signed also with the certificate of acknowledgement by a notary. There is an alternative, and that alternative is the witnesses. So if you look down here, if you don't feel like coming into the offices, you can say, okay, I'd like, my two neighbors to come over, put in their signature, the date, their residence address, and they can choose to do that. One of the witnesses also needs to indicate, if you look at the bottom of this document, page 8 of 8, that they are not related by blood, marriage, or adoption. So you can have two neighbors come over and witness your signature. All right. Again, if you have any significant questions about this or you want to know more information, you can contact our offices on this. This is a really key document to providing medical care for someone who cannot speak for themselves. And what you want to do is get this document, a copy of this document to, and I'll read down here what it tells you. Use your retained and executed document of this document and give one to your agent. The power of attorney should be available so a copy can be given to your providers of healthcare. So give it to your doctors as well. This includes requesting the Nevada Secretary of State to electronically store this document with a Nevada lockbox so that healthcare providers can access it. So what does that mean? This document can be accessed online by healthcare providers. However, you must make sure that you take a copy of it and send into the Secretary of State. So that's your responsibility. We're going to look at that website next. Okay. So if you can see the screen here, it is under Nevada Secretary of State's online services. It's called nevadalockbox.nv.gov, protecting your wishes. There is, with your completed durable power of attorney, you need to get a registration form from this site, put those together, and mail it to the Secretary of State. Okay, so that's the way that you get this document online. They will eventually send you back a document that says, yes, we have your information. And there's little tiny stickers that I don't have my license with me, or I would show you. On the back of my driver's license, on the front it says organ donor, and on the back I have a little tiny like a peel off sticker that says Nevada lockbox. That's this information. So God forbid, if I'm in an accident, REMSA is going to pull out and look at my driver's license and say, okay, here's her name, she's an organ donor, and hopefully take a look at the fact that I also have my healthcare decisions in Nevada lockbox. So REMSA, which is our state ambulance service, can look that up. In our hospitals at Renown, Northern Nevada Medical Center, St. Mary's, they can also look up what are that person's wishes. So this is a really valuable tool that our state has, and it is a free service provided by the state. Okay, so we're going to move on to our next documents. Okay, I'm going to stop sharing for just a minute as I go take a look at, see if I can find our next documents here. All right, so I only have one of two of these documents. When you get a packet from our office, it will share with you the details, and that things that we don't really want to look at. One of them happens to be our what will happen in the event of death. So this is one of two documents. This is an affidavit authorizing cremation. There's also, looks exactly the same pretty much, which says affidavit authorizing burial. It's not required for you to fill this document out like any of these. These are not required documents. However, some people choose to have this done as a kindness for the person who will be responsible for these things. So let me just go through this here. It says, and this is a notarized document, so you want to have a notary take care of it. Affidavit authorizing cremation of the individual's name, your name, state of Nevada, county that you reside in. For us, it's Washoe. The date, you put your name in. I, Jane Doe, do hereby designate, and wherever this may be, the healthcare agent could do it. You could also potentially put in, for example, one of the well-known funeral homes, Walton's Funeral Home, to order the cremation of, and then it goes on to indicate, of human remains upon death to be received by disposed as follows. So you may choose what happens after that. So you could choose, provided your estate has enough money, a particular urn, or scattering if you have individuals who are willing to do that for you, and then signed by the individual, yourself, and the date, and then subscribed and sworn before the notary. So this is one document that you could choose, the alternative, and the packet comes with both. So authorizing burial. So that would also, you would want to include where exactly you have in mind, one of the local cemeteries or elsewhere. If you have, you know that there's a burial site that's in another state, you may want to choose to have those funds set up in advance and the information about death put into these documents. So, all right, and we're going to go stop sharing the screen for just a moment while I go look for the next documents here. So we've gone over durable power of attorney, the burial, as well as cremation, and pulling up hopefully another document. Sometimes with Zoom, it takes a moment to load. So we're working on loading the document here. Okay, this goes along with the durable power of attorney. And back to screen share here. All right. So this document, and part of the reason I know we covered all of this previously, I know that it's in part of the durable power of attorney, but in our state, sometimes legislation takes a while to get done, and sometimes it's done piecemeal. Well, this was kind of a piecemeal piece. And so it is a helpful and really important piece to make sure that you include with your durable power of attorney for healthcare. This specifically deals with food. So I'm going to read the top. Declaration concerning the withholding of life-saving treatment of the individual's name, Jane Doe, whatever your name is, should be put in there. Then we're going to look at these two options. So withholding, and I'm skipping down to the indented paragraph. Withholding or withdrawal of artificial nutrition and hydration may result in death by starvation or dehydration. Initial this box if you do want to receive or continue receiving artificial nutrition and hydration by way of the gastrointestinal tract after all other treatment is withheld pursuant to this declaration. So you would put your initials in there if your choice is to be fed. And what happens is initially an NG tube, a nasogastric tube is put in, sometimes an oral gastric tube, but most often nasogastric. But because if it goes on for a long period of time, it erodes the inside of the nares, it needs to be put in a permanent way. So there's an operation that's done for a gastrostomy. So a tube, that tube would be removed, the one from the nose, and an operation would be done to maintain feeding of some kind of supplemental nutrition, such as Ensure, on a continuing basis for individuals who are in comas for long periods of time to basically keep them alive. So this would ensure, given if an individual was living but not able to eat and may or may not have brain damage, so the operation would be done as long as there was no other, infection or other source of something that would cause the person to die rapidly. The operation would be done and they would continue to receive hydration and artificial nutrition. So the second one is initial this box if you do not want to receive or continue receiving artificial nutrition or hydration by way of the gastrointestinal tract after all other treatment is withheld pursuant to this declaration. So again, I would refer you to the Hospice Foundation of America's website with regard to nutrition. In hospice cases, it is the thing that prolongs dying. It does not increase length or quality of life, generally speaking. And again, it depends upon the individual situation. There may be times when it is absolutely appropriate and completely expected that nutrition would be maintained. However, it is the thing that does keep people alive. So it's a choice, regardless of dementia, regardless of other complicating factors, and maybe something you need to speak with your spiritual advisor about as to what might be the appropriate choice. So this one would sign, making their choices by initialing, and this one can be done by either a notary or you can have the neighbor kind of witnesses come over and look at that. So at any rate, those are the healthcare documents that we are looking at today, and we're going to move on to the financial documents. So again, just working on finding the financial documents, and give me just a minute here. All right. So this is a power of attorney for financial, and this document is relevant between the time of someone's illness and before their death, because following their death, a will is the thing that takes precedence. But there may be a time period, whether it's a couple of weeks or a couple of years in between, when a power of attorney for financial decisions is a helpful document to make sure that your wishes are followed. So again, this has a preamble that you can take a look at. Same deal as the power of attorney. I put in your name, designating whoever it is you choose to designate. It can be the same person that's your healthcare agent. It does not have to be. And here in number 2, the alternate agents. So first person and second person. Again, you can choose the same healthcare agents and alternates, but there's no requirement that you do that. Any information that you have, email addresses, there's no line for that, but you can absolutely add that information. So this, it states, I grant my agent, any successor agents, general authority to act for me with respect to each of these, or if you look at the very last one, it says all preceding subjects. So if you have an individual that you choose and you trust, you may initial the bottom. It will give the agent general authority to take care of whatever it is. So whether that's real property, stocks and bonds, if they need to pay out for healthcare providers to come into the home, you could do all preceding, that you can have them file your taxes if that's necessary, or take care of whatever legally that you want them to take care of. So there is a provision under number 6 to grant specific authority or allow them not to do what you don't want them to do. So let's see, you can choose under number 6 that they cannot change a beneficiary designation. So once you give someone general authority, and if an individual has, say, a life insurance policy, they could change your beneficiary. So instead of going to daughter number 1, it could go to daughter number 2 or someone else, anyone else. You may check this box, or I'd say initial it, if you don't want them to change beneficiaries, for example. And you can look at each one of those provisions and make a decision with regard to those. So number 7, this regards, again, living arrangements. So we're going to read each paragraph here under number 7. It's my intention to live in my home as long as it's safe and my medical needs can be met. My agent may arrange for a natural person, employee of an agency, or provider of community-based services to come into my home to provide care. When it's no longer safe for me to live in my home, I authorize my agent to place me in a facility or home that can provide any medical assistance and support in my activities of daily living that I require. Before being placed, I want my agent to talk to me about it. Okay, so that's allowing your healthcare agent to make those choices. Or number 2, and again, read this paragraph. It's my intention to live in my home for as long as possible without regard for my medical needs, personal safety, or ability to engage in activities of daily living. My agent may arrange for a natural person, employer, agency of a provider of community-based services to come into my home and provide care for me. I understand that before I can be placed, a guardian must be appointed. So again, this is similar to the previous durable power of attorney for healthcare. In either A, your healthcare agent gets to do it, or B, a guardian is employed to do this. So again, these documents do not come into play until an individual cannot speak for themselves. As long as the individual is able to speak for themselves, then whatever that individual says goes. But when that cannot happen because of illness, then these documents are relevant. So, and if there's anything else, I desire my agent to take care of the following actions. So whatever that is, if it's going into making sure that the burial is done appropriately, arranging for funeral, you could put that in here. You could put it into the other document that we looked at. If it's scattering ashes, you could put that information in there if you wished as well. Any other information, something with regard to pets is an important piece that you might want to consider. If you have pets living when you need to be in a facility that doesn't allow pets, what will happen to those pets? Will your estate be able to take care of them, or would they be put at the SPCA? Something like that. So, any limitations you want on your agent's authority? That's number 8. Special instructions, additional authority, anything else that you can think of. So, number 11, another legalese piece that we probably need to talk about. So, you can choose one or both under durable. So this power of attorney shall not be affected by subsequent disability or incapacity. So when you have signed this document, if you want it to keep going, which makes the most sense, you will want to initial the first one, durable. So even if an individual is later declared incompetent, this document takes precedence. So it would continue going. So springing power, let's read that. It's my intention and direction that my designated agent and any person or entity that my designated agent may transact business with on my behalf may rely on a written medical opinion issued by a licensed medical doctor stating that I'm disabled or incapacitated or incapable of managing my affairs, and that said medical options shall establish whether or not I am under a disability for the purpose of establishing the authority of my agent. So in other words, this pretty much requires a physician to indicate that the individual is disabled and brings this document officially online. So in the first instance, an argument could be made that no matter what, the agent has the ability, as long as the first section has been initialed under 11. And B is there may be required a physician's note that says, yeah, this is what they wanted. And here's the doctor's proof that the individual can't do it for themselves. Okay. One could choose a specific date on which it becomes effective or a date to terminate this document. All right, so basically that's it. Moving on to having a notary and talking about, you really need to tell whoever it is that you've asked them to be an agent and really be upfront with them, be transparent and explain what your choices are. Say, look, if I become incapacitated or, there's dementia or something, over the event horizon, I want you to know that you are designated as my financial, and if you also have them as the healthcare agent, and my healthcare agent. So I want you to know that, and here's what I want you to know about my further placement. If it becomes necessary that, 10 years down the line, I can't take care of myself or something, then you have that ability to make that choice for me. So you'll want to have that conversation very bluntly, plainly, and openly, so there's no question on the part of your agent as to what it is you want. Okay. So I think that that's it. We're going to go to the bottom of the document and make sure. Yep, that's it. Okay. Again, if you have any questions about these documents, they're not perhaps always the easiest to understand. There's a lot of legalese in them. They're legal documents. So you can contact our office, but the packets will go out. If you would like to fill one out, just contact Nevada Legal Services. So thank you all for letting me be here today. I very much appreciate that opportunity. So be well, and